George Mitchell, Chesterhall, Ltd v. Finney Lock, Seeds Ltd, 1983. A seedsman sought to rely upon an exclusion clause preventing any claim by a purchaser by way of set-off against its sales invoices. The House was asked whether a contractual term was fair and reasonable within the meaning of Section 55 of the Sale of Goods Act 1979. Where a tribunal applies a standard with a greater or lesser degree of imprecision and takes a number of factors into account, there will be cases in which it will be impossible for a reviewing court to say that the tribunal must have erred in law in deciding the case either way. Lord Bridge of Harwich said, the decisive factor, however, appears from the evidence of 4 witnesses called for the appellants, 2 independent seedsmen, the chairman of the appellant company, and a director of a sister company, both being wholly owned subsidiaries of the same parent. They said that it had always been their practice, unsuccessfully attempted in the instant case, to negotiate settlements of farmers' claims for damages in excess of the price of the seeds, if they thought that the claims were genuine and justified. This evidence indicated a clear recognition by seedsmen in general, and the appellants in particular, that reliance on the limitation of liability imposed by the relevant condition would not be fair or reasonable, and there will sometimes be room for a legitimate difference of judicial opinion as to what the answer, under S11, should be, where it will be impossible to say that one view is demonstrably wrong and the other demonstrably right. It must follow, in my view, that, when asked to review such a decision on appeal, the appellate court should treat the original decision with the utmost respect and refrain from interference with it unless satisfied that it proceeded upon some erroneous principle or was plainly and obviously wrong. A decision as to reasonableness is akin to the exercise of a discretion.